Mr. Beat presents Supreme Court Briefs.
Oklahoma City, Oklahoma, September 12, 2012. The Green family, who owns and operates Hobby Lobby Stores, Incorporated, sues Kathleen Sebelius, the United States Secretary of the Department of Health and Human Services. They were challenging the Patient Protection and Affordable Care Act, also known as Obamacare, because part of that law went against their religious beliefs. You see, the Green family were evangelical Christians and had long publicly said that they ran Hobby Lobby, their very popular arts and crafts store, according to the principles of their faith. Under Obamacare, employment-provided health insurance had to provide certain types of preventative care, including some contraceptive methods, aka birth control. Well, the Greens thought that contraception was immoral and went against their religion. They argued that the contraception requirement of Obamacare went against the free exercise clause of the First Amendment. Not only that, they also said it went against the Religious Freedom Restoration Act of 1993, or RFRA. Okay, I'll just say RFRA, a law that Congress passed that basically strengthened religious freedom in the country. No. The Supreme Court had weakened the RFRA in a case called City of Bernie v. Flores. In the U.S. District Court for the Western District of Oklahoma, District Judge Joe Heaton denied the Green family's request to have the federal government not carry out the requirement of Obamacare that employment-provided health insurance had to cover contraception. Heaton said that while there are exemptions available for religious employers and nonprofit religious organizations, for-profit retailers like Hobby Lobby did not get exemptions. The Greens were like, nuh-uh, and appealed to the U.S. Court of Appeals for the 10th Circuit. It said Hobby Lobby is legally a person and therefore has religious freedom. Therefore, Hobby Lobby should be exempt from the contraception requirement. By the way, Neil Gorsuch, a future Supreme Court justice, ruled with Hobby Lobby in the U.S. Court of Appeals for the 10th Circuit decision. As it turns out, the Greens weren't the only ones suing Kathleen Sebelius over the contraception requirement, going against their religious beliefs. Mardel, a Christian book and educational supply store, as well as Conestoga Wood Specialties, a Christian manufacturer of cabinets and furniture, also fought back against it. The Supreme Court decided to combine all their fights into one case and heard oral arguments on June 30th, 2014. These oral arguments lasted an hour and a half, 30 minutes longer than most. By the time the court had finished considering this case, Kathleen Sebelius had resigned as the U.S. Secretary of Health and Human Services, and Sylvia Burwell had taken her place. For this case, the court had to consider whether or not the free exercise clause of the First Amendment protected a for-profit religious employer's right to be exempt from the Obamacare requirement that employment-provided health insurance had to cover contraception. Whew. Apparently, it did. On June 30th, 2014, the court announced it had sided with Hobby Lobby, Mardel, and Conestoga Wood Specialties. It was 5-4, with the 5 politically right-leaning justices having the majority opinion and the 4 politically left-leaning justices having the dissenting opinion. The court argued that because the contraception requirement of Obamacare forced religious corporations to pay for what goes against their religious beliefs or face fines, it indeed went against the free exercise clause of the First Amendment. That said, the court said that the contraceptive mandate was specifically the only part of Obamacare that was unconstitutional. In addition, the court stated the RFRA was constitutional and, yep, indeed applied to corporations, thus reinforcing the legal idea of corporate personhood. In his concurring opinion, Justice Anthony Kennedy wrote that the federal government hadn't proven that there was actually a meaningful difference between non-profit religious organizations and for-profit ones. Oh, snappity snap. Justice Ruth Bader Ginsburg wrote the dissenting opinion, arguing that this decision could lead to a slippery slope. She wrote, quote, "In a decision of startling breadth, the court holds that commercial enterprises, including corporations, along with partnerships and sole proprietorship, can opt out of any law, saving only tax laws, they judge incompatible with their sincerely held religious beliefs. The court suggests there always will be whenever, in lieu of tolling an enterprise claiming a religion-based exemption, the government, i.e. the general public, can pick up the tab." Basically, she was concerned this decision might just lead to more and more corporations trying to get out of laws and get out of covering the needs of employees. Burwell v. Hobby Lobby is yet another recent controversial Supreme Court decision. Critics said it was a step back for reproductive rights and gender equality, as the decision arguably disproportionately hurts women who rely on employer-provided health insurance for contraceptive coverage. Others criticized the decision for expanding the definition of religious freedom to include corporations, which technically are legal entities, not individuals. Finally, even others have argued that Burwell v. Hobby Lobby potentially opened the door to other types of discrimination under the guise of, quote, religious belief. That said, while several other court cases challenged other parts of Obamacare in recent years, the law remains popular with most Americans. I'll see you for the next Supreme Court case, jury. Do you agree with the Supreme Court in this decision? Why or why not? Let me know, okay? Gosh. And now it's time to thank my Patreon supporters and channel members. So thank you, Patreon supporters and channel members. And here's a shout out I do almost once a month to my Patreon supporters who donate at least $15 or more each month to my channel, starting with my biggest donors alphabetically. Thank you to Alicia Solberg, Andrew B., Anthony Beckett, Austin Ciros, Chris McKinnon, Chums McGuffey, Corey Ryman, Elias Pierce, Empty Machine, Jeremy Dunham, Joe Cook, Justin Miller, Mater Tenebrarum, Nicholas Dronsky, Nick Everett, Pat Iapicca, Patrick Stewart, Raquel Jones, Sean Connett, Zach Anderson, Zachary Pescalar, Adam Christians, Aditya Anand, Andrew Snyder, Emily Glover Wilson, Grant Gagaza, Jack L., Jacob Birnbaum, Josh, Joshua Jackson, Michael Burt, Naderade, Nathan Hale, Navictatron, Ralph, Salty, Steve Bryan, TC, Thomas Oppenheim, Ty Marwitz, Victor McLean, and Zachary F. Parker. Thanks to all my Patreon supporters, and thank you for being curious.